This might be, in fact, probably is the greatest stress test American democracy has ever faced. I personally am very, very happy to have Ellen Katz here, law professor at the University of Michigan Law School, for our first take conversation about how our democracy has fared during this stress test. Ellen Katz, the Ralph W. Egler Professor of Law, writes and teaches about election law, civil rights and remedies, and equal protection. Her scholarship addresses questions of minority representation, political equality, and the role of institutions in crafting and implementing anti-discrimination laws. In addition, she created the Voting Rights Initiative at the law school to provide data about the past and present status of minority participation in the political process. The findings have served to inform courts, Congress, and public debate. Professor Katz has published numerous articles, including an influential empirical study of litigation under the Voting Rights Act. Prior to joining the Michigan Law faculty, Professor Katz practiced as an attorney with the appellate sections of the U.S. Department of Justice's Civil Division and its Environment and Natural Resources Division. She was a judicial clerk for Justice David H. Souter of the U.S. Supreme Court and for the Honorable Judith W. Rogers of the U.S. Court of Appeals for the D.C. Circuit. She earned her J.D. in 1994 from Yale Law School, where she served as articles editor of the Yale Law Review. Yale Law Journal. She graduated summa cum laude from Yale College in 1991 with a BA in history. Professor Katz, we're so happy to have you. Thank you for joining us.
Laura, thank you for having me. And thanks to you and to Shelley and Christine for setting this all up and for the invitation. And I'm told I should talk for 20-ish minutes. I will try to do that, but I really do welcome a conversation about the thoughts and things that you're all concerned about or still willing to talk about in this election after so much discussion has already happened. I looked at the title that you gave to the talk, We Survived, How's the Health of Our Democracy? And in many ways, the question there is how you define those terms. Did we survive? How is the health? Depends on how you define all of those things. So a quick and dirty conclusion, if you define surviving that Joe Biden will be inaugurated as president on January 20th, I'm confident that that will happen. And if that is indicative of the health of our democracy, sure. In talking to my students over the past months about this, sort of have come up with this image of democracy being held together at this moment by duct tape, and that it's sort of holding at various places, and that in many senses it will hold, but we have seen, and I think as Teresa's introduction suggested, there's this sense of so many places where it could have collapsed, and still reason for concern. One of the reasons I'm skeptical about the title, and I am concerned beyond the inauguration, is some of the things that you already alluded to in terms of the discourse, the number of people in the country right now who are convinced that this election was secured by fraud, and the difficulty or the disagreement among so many people about the legitimacy of it. And I think the trope of a stolen election is not just is an ominous one, and one we will have to be dealing with well beyond January 20th. And I do worry deeply about the health of our democracy, so to speak, when we think about those things in the longer term. And that even in the shorter term, and just thinking of the last weeks and months and the few weeks ahead of us now, the health of our democracy, the survival of it, has turned, I think, on literally millions of decisions along the way by lots and lots of different people, many of whom had to do what my kids might say, the bare minimum that one might expect from a citizen acting in good faith. many people who had to do quite heroic things, and then a whole lot of people had to do the right thing. And I'm finding myself challenged over the last weeks in sort of separating those acts out. Last night, what we saw happen in Wayne County, one might say that that resolution was the bare minimum that one should expect from people exercising official power to certify the results of the election. Folks standing in line for hours and hours, up to 12 hours in places in Georgia, and some of the early voting that happened there, I will call that heroic. We can talk more about the circumstances that have given rise to that. To my mind, those are conditions no one should be having to endure to cast a ballot in the United States in 2020, and yet obstacles of that sort have been not just confronted by voters in various parts of the country, but upheld as sufficient for what we are constitutionally entitled to. And I find that a troubling development, to say the least. And then there's a lot of decisions that are going on that I might say, is that the bare minimum or is that heroic? And frankly, I look at some of the things that are happening in Georgia right now and the actions of the Georgia Secretary of State in particular, and what I might have a few weeks ago called the bare minimum, I might now be rising to the level of heroic. And so it's interesting to think about how we understand that. And when we're talking about issues of health and we're talking about survival in this democracy, a lot of those terms I think are varied. So one of the things I like about presidential elections is someone who teaches about voting for many years now. It's sort of the civics lesson that it provides to the country. And each time we learn some fun new things. We learned this time, and a lot of attention was given to the fact that the declaration of winners on the night of the election are always just projections, and that the certification process takes longer. It always has. There's always been this process that we're seeing. That mail-in voting is a thing. That's a thing that's been going on in this country for a long time in a lot of jurisdictions. Obviously, it's expanded in scale. The variations in rules that we see from jurisdiction to jurisdiction is something. We have a decentralized system. States get to decide lots of these different rules. The federal law does not dictate a whole lot of stuff, and so we do see immense variation from place to place. And of course, this year we saw the pandemic and the way in which that changed dramatically the way many of us voted, and the way folks who were implementing this election had to adapt and accommodate in real time to changing circumstances. And while we heard along the way about lots of troubling things that happened, it's also worth to take note of the thousands and thousands of local officials who worked in good faith and really did, I'll use that word again, heroic service in accommodating what needed to be accommodated. And so, there's reason to be encouraged, and there's reason to be concerned. Let me say a few things. I guess there's a question of how much detail to go into right now, and it depends a little bit on how much, where your interests lie. But let me back us up in thinking about this and go back to April, when I think some of the legal challenges that this election was going to presented first became clear. And it was in April where we saw the Wisconsin primary, which was one of the first primaries to really bear the brunt of the changed circumstances of the pandemic. And what we saw happen in Wisconsin, it was also the case that generated the first Supreme Court intervention in this election. So Wisconsin primary was April 7th, I believe, and just as the pandemic was unfolding in March with stay-at-home orders and the like, voters in Wisconsin began requesting mail-in ballots at a rate that Wisconsin had never seen before. And Wisconsin allows absentee ballots on demand. State and local election officials were running out of envelopes, literally, and did not have the ability to keep up with the request. And as the election got closer, it became clear that in the primary, many people who had requested primary ballots absentee ballots were not going to receive them in time to turn them around and get them back in time to be counted. There was a lot of wrangling. It's divided. It's like Michigan in the sense of one party holds the legislature, another party the governor's office. Should the election be postponed? Should the legislature pass rules to accommodate this problem? None of that was able to be resolved through state law, and a federal lawsuit several federal lawsuits were filed challenging the burden that the rules were causing for so many voters. And again, this was the early days of the pandemic, and the notion of the risks that folks confronted in standing online, waiting in crowded places were still things, I mean, continue to be sources of concern and still things that we were worried about at different levels. And so the lawsuits were asking, among other things, for additional time to cast the ballot, to count, additional time for Wisconsin to receive the ballot beyond actual election day. Long and short of it, and there were other issues as well, but the issue that sort of gets teed up and ends up in the Supreme Court is this question that we saw many other times in other jurisdictions, the same question. Could ballots that were received by election officials after election day still be counted? And a federal lower district court in Wisconsin, adjudicating the Wisconsin case, said, yes, we're going to extend the date because so many people have requested these ballots and will not be able to receive them, fill them out, and get them back to an election official by election day. And it was extended for a period of several days after the election. It goes up to the Supreme Court. And this is a famous if you're following it, it's a 5-4 decision. It's a per curiam, there's actually no author for the majority. And then a dissent written by Ruth Bader Ginsburg in one of her, what turned out to be one of her final decisions, objecting. And the court displaces the lower court order and says, no, federal courts should not be intervening. Federal courts should not be intervening in state elections. There are a lot of ways to run an election, during a pandemic, and federal courts ought not to be dictating rules to local officials so close to election day, changing the rules at the last minute. There's a lot to be said about the decision. And one of the things that I think is notable about it, in part because I think it foreshadows much of the litigation that came after, was this divide on the court. This language from the per curiam, the majority, arguing, we're not getting involved. This is not something for federal courts to be doing. This is up to Wisconsin. If you're unhappy with this situation, go yell at the Wisconsin legislature or go yell at the Wisconsin governor, but it's not something that federal law speaks to. In the meantime, Justice Ginsburg's dissent charges the majority with causing massive disenfranchisement, putting voters to the untenable choice of either risking their health and safety by showing up in person at the polls, or not voting entirely because they can't put themselves at that risk. Maybe because of they themselves have health conditions, they care for others. You may have seen this photo of a woman standing in line with a mask on in Milwaukee, where 150 polling places closed on the eve of the election because they couldn't get enough polling workers. And she pointed out that she had requested an absentee ballot. It hadn't come, and here I am risking my life and that of my family. Her father was ill, to vote. And the sense that we should be better than this. This is not the way the right to vote should be devolved or shaped at this point. And one of the things, this might get us a little bit into the weeds, but one of the things that I think is so important about that decision, and why I might call it ominous, or more to the point, foreshadowing where we are now, was the majority's response to the charge of disenfranchisement. The dissenters are saying, you're disenfranchising people. You've put that the system as we find ourselves at this moment is causing voters to make this choice that Justice Ginsburg and the other justices in dissent understood to be an untenable one, and one that represented an undue burden on the right to vote, for which the state had no adequate justification. It denied the right to vote as protected by the Constitution. And the majorities, no, we are not disenfranchising anybody. There's no disenfranchisement here. All that's really going on is the federal government, the federal courts are not intervening. Underlying that holding, though, is the understanding, I think, the belief that it doesn't violate our constitutional rights. It did not violate the constitutional rights of Wisconsin voters to be put to the test or be put to the choice. Either don't vote or risk the line. that was a choice that voters had because the absentee ballots that they had requested, the mail-in ballots they had requested timely that they hadn't received, that they couldn't get back, if they wanted to exercise the right to vote, wait in line or don't vote, that choice itself is sufficient for what the Constitution requires. And that, I think, is notable for the ease with which the majority of the Supreme Court at the time, and I suspect the majority of the new Supreme Court now, feels that's not an intervention, that's not an intrusion, that's not an unconstitutional burden on the right to vote. The decision doesn't come out and say it explicitly, but it's a necessary consequence of its holding. And I think it's something that we see, and we could talk about many other cases that come along, many raising this very same issue about counting ballots after the action that are received after the day of election. But a whole iteration of other rules. How many do you need to get your absentee ballot witnessed? What are the signature requirements for throwing out a ballot for matching? How many drop-off spots ought there be? Are you even entitled to an absentee ballot if you are not someone who's of the, in Texas, there was a whole lot of dispute about this. People of certain ages were eligible for it. People with, certain excuses, but if the listed excuses didn't apply to you, could merely the risk of voting during the pandemic be sufficient, voting in person be sufficient? That's up to Texas. And we saw a whole bunch of these rules play out, modifications that are being made. And basically time and again, federal courts have held consistently, and sometimes the Supreme Court through denying stays, entering stays, affirming this idea that there's a mix of procedures here. And so long as voters retain the legal right to cast a ballot somewhere, their constitutional rights are met. And I think that was a significant encroachment on an older understanding of what the right to vote was and what it should look like. There's much more to be said about this. There's the complication of when that same holding is reached by a state court, and we saw this in Pennsylvania. And this was sort of more recently with the Pennsylvania Supreme Court extended the days for receiving the ballots, much like the federal court in Wisconsin had done, but did it through a construction of state law and the state Supreme Court's understanding of what the right to vote means in the state of Pennsylvania. And that brings up, and again, I'm not going to go into it in terrible detail here, but I'm happy to talk about it more, questions about the so-called independent state legislature doctrine under Article 2 of the Constitution. And for those of you who remember, this was churning around in Bush versus Gore, and 3 justices in Bush versus Gore actually subscribed to this view. Basically, a state court may act in a way that usurps the power of the legislature, the state legislature, to decide the rules by which electors are selected. Lots of people were very worried about this, and there were various decisions by the Supreme Court both in the Pennsylvania case and in related in litigation that suggested that the court might displace the Pennsylvania ruling under the Pennsylvania Supreme Court's ruling on this independent state legislature ground. We never saw that case actually ruled on its merits, and you might have heard things about segregating ballots in Pennsylvania because the margins were such that the ballots that were submitted late or that were received late never made enough of a difference. And so to get back to sort of where I started, the sort of idea of democracy being held together a little bit by duct tape here, had the margins been different 2 weeks ago, had the case come down to Pennsylvania, had the case come down not just to the vote in Pennsylvania, but those 3 days, those ballots received the 3 days afterwards, we would have been in a tough spot. And I mean a tough spot not simply for those who wanted one candidate or another to win, but rather for the way and the process by which that would be resolved, because it would have gone up to the Supreme Court for a resolution. And I think at this moment in time, it's a deeply worrying concern about the type of intervention that they would have done, at least to my mind. I have some notes here that I'm looking at. I have many other things we could be talking about. I'll stop in just a moment. Let me just add this thought. I think one of the reasons, I I've spent a lot of time over the last years thinking about federal court decisions construing the right to vote under the Constitution or federal statutes, particularly the Voting Rights Act. And I think one of the things this election has shown me is the inadequacy of the traditional methods by which we have vindicated the right to vote in this country. That federal law and federal courts are not the place in which plaintiffs who are seeking more expansive notions of political participation, or maybe the bare minimum of what one hopes participation to be, but certainly challenging state laws as not giving them adequate opportunities to participate, are going to find very little relief in federal courts. And I think that's going to last for a long time now. That's the venue where the right to vote was vindicated back in the 1960s in seminal decisions, adopting a very expansive conception of the right to vote. It frankly is the story of the Voting Rights Act and the story about lawyers enforcing federal law, both statutory and constitutional, that sort of made people of my generation want to go to law school and become lawyers because it was about justice and fairness and all of that stuff. And when I think about now the road forward, and what my students want to work on and the things they might do, the places where I think progress, where more expansive conceptions of political participation are likely to be vindicated, are not in these traditional venues, but actually under state law in particular. And so one of the things I'll stop in just a moment here, but one of the things I think was amazing was what voters in Michigan did in 2018 with Prop 3, which was the Promote the Vote amendments to our Constitution that vastly expanded the way we participate. Absentee ballots on demand, we only got that in 2018. Automatic voter registration, same-day registration. I would say common sense legal reforms, but they make a difference in the places where they have been adopted. So it's there are places to work and struggle for progress, or at least as I will define progress, which to my mind is rules that make it easier rather than more difficult for people to vote. And the places where we're going to see that happen, I do think, are through ballot initiatives and mechanisms of that sort, as opposed to the traditional tools that we've had seen for decades. So let me stop there. There's a lot, I see stuff in the chat. Teresa, do you want to just ask the question?
Yeah, I've got a bunch of stuff, so thank you so much. And I'm going to ask for help from Shelley and maybe Rena, in monitoring the chat, just because I have a document up too. So so I could use some help. So go ahead and break in. But I also just wanted to point out, and I don't know if this was said before, that the League is a nonpartisan voter education organization. This isn't for you, Ellen, it's for everybody else. Just to be clear, that it's a nonpartisan voter education organization. So any statements that we make about statements of fact about political parties are not intended to be partisan or to express partisan preferences. So I just want to make clear that applies. So Ellen, there's so many questions to ask, and I'm going to start with a couple, and I know there are some in chat. One is, you mentioned, of course, the Voting Rights Act, and of course, I think it's HR 1. I can't remember the name of the HR 1 that the new Congress in January 2019, the first bill they passed went a long way in making voting easier. And then, of course, there's the John R. Lewis Voting Rights Act as well. Those, of course, have been on Mitch McConnell's desk for 2 years and counting. So what, I guess a question is, what are the, I don't want to ask what the chances of getting those passed are, because I think they're very low if the Senate stays in Republican hands. But what actions could an executive take? What actions could the White House take that would stick, that would increase access to voting?
Right. So I had been imagining a few months ago, or not that long ago, things Congress might pass that could help. And there are a lot of things that could be done. I think any, HR 1 has a lot of things in it that would be super. I think anything that is that Congress were to pass needs to be mindful of the legal challenges that will come.
Yeah.
And so, we saw, so I'm going to not answer your question, I think is what I'm doing. So there are straightforward rules. I think there are things that Congress could do for federal elections in particular. Congress has a power under Article 1, Section 4 of the Constitution to set rules for the time, place, and manner of federal elections. And we can discuss what is a time, place, and manner regulation versus a qualification for voting, which remains in state hands. And there's actually a lot of difficulty about certain kinds of qualifications. And again, this is a digression here, but we can talk about Florida's effort to keep people with criminal records from re-entering the electorate despite a constitutional amendment there. And what's happened there is difficult. I'll leave it at that, but we should talk more about that. But I think there's a lot of, some of the stuff that we did in Michigan, you could imagine being done at the federal level for federal elections, automatic voter registration, rules, amendments to motor voter. A few years back, there was this expansive ruling that allowed states, Ohio was the plaintiff in that case, that was the defendant in that case regarding voter purges, that allowed states to kick people off the voter rolls through a process that I'm of the view gave voters insufficient protection. Congress could make it more difficult for people to be thrown off the rolls, particularly for not voting, which is obviously everybody's right. Congress could have absentee ballots on demand. Congress could mandate early voting and resolve a lot of the specific issues that we saw that came up this time around in terms of absentee ballots that show up late, that are mailed before but received after. Rules about ballot harvesting among folks who can't get to the drop-off boxes or bring their and things, and we've seen that in Native American communities in particular, difficulties there that were confronted. There's a case in the Supreme Court that we heard in the spring from Arizona about out of precinct voting, meaning you show up at the wrong precinct, cast a ballot. Arizona's practice is to throw all the ballot. If you are in fact at the wrong precinct, you file a provisional ballot. Arizona will toss that ballot if it turns out that you are in fact in the wrong precinct, even though you are eligible to vote for the Senate, the governor, the House, perhaps, depending, you're in the wrong, maybe there's a city council, maybe there's a local race for which your ballot's incorrect, but most of the races are fine. Arizona throws out the ballot entirely. There are things that Congress could do were it so inclined. And that case is actually, it's quite interesting because it's being litigated under the Voting Rights Act, and the notion that practice has a racially disparate impact results in a denial of an equal opportunity to participate. We'll see what happens there. I suspect this court is going to find no violation of the statute, but we shall see. So I think there's a lot that Congress can do. There's things Congress can do to reach into state and local elections, and on that front, it's more difficult because the law has moved in recent years, or not so recent years, and I think many people are familiar with the Shelby County decision from 2013 that struck down the core provision, or rendered inoperative, the core provision of the Voting Rights Act that really protected minority voters in a very meaningful way, and we've seen a lot of the repercussions from there. Work to Congress to reenact something of the sort that was taken away, there will be a legal challenge and it will go through the federal courts. And
does the legal challenge come from states?
Yeah, I mean, she came from a county, but sure.
Yeah, right, okay, yeah.
And it depends on what the provision is, but it could be any of those rules for federal elections that I just mentioned, absentee ballots on demand, or out of precinct voting. Let's use the absentee ballots on demand. States would say, well, we don't want to give absentee ballots on demand. We only want to give them in limited circumstances. Does Congress have the right to displace the state practice? And that question turns on the scope of Congress's power to enforce the 14th and 15th Amendments if it's reaching state and local elections. For federal elections, Congress actually has far greater power just because of the way the Constitution defines federal power. And so anything that's reaching into state or local elections will be challenged in a Shelby County type claim, which is not to say that it won't survive scrutiny, but it will have to convince people that the new statute is sufficiently different from the older one. I don't think the Supreme Court has gotten more receptive to that kind of
Right.
in the years since Shelby County. Although the record of the things that have happened and the type of voter suppression methods that we've seen, deliberate efforts to make it more difficult to vote, might in fact, to my mind, help make a case for legislation of that sort. But I am not the person making a decision about those things. So what I did answer your question is what can the White House do if the Senate stays where it is? And that's more difficult. I don't know. There are things the Justice Department can still do in terms of sending observers and monitoring elections. Maybe a strategy is to think more piecemeal about some of these specific. Congress can do a lot in federal elections, and I would like to think that there would be bipartisan support for some of these measures. And so perhaps to think more piecemeal about limited things that could get passed.
But it sounds like you're somewhat despairing of the ability of the executive to make meaningfully improve access to the ballot.
I think there are limits to
rules changes or who knows what. I don't know enough to.
Yeah, no, there are things, the motor voter, there are the Help America Vote Act, there are provisions that could be enforced. And certainly a receptive Justice Department can use existing tools to do more than has been done in the last 4 years to protect the right to vote. Mm-hmm. For those of us who were thinking more about, should HR 1 be amended to add, more stuff or more goodies, or we're thinking of something more sweeping, or, in that light, these things do seem lesser. So we'll see what that'll look like.
Yeah. Okay. I have a bunch of questions here. Let's see. How can we solve the problem of people who appear to be living in an alternative reality regarding the election results? What can we do about those who refuse to accept facts, even in the midst of overwhelming evidence?
I don't know how to answer that question. I mean, and I think, it goes back to your title for this discussion, and our survival, quite frankly. And lots of that has very little to do with concrete, legal questions. We can talk about the scope of Congress's power. We can talk about what federal courts are likely to do, what state courts can do, what we can do in amending our constitutions. What we do about, I don't know what is the word for this, polarization, diametrically opposed views that so many people have about what the world looks like at this moment, I don't know the answer to that, and that's the part that I'm pessimistic about. About how we find common ground. I tell my students, because they're very young, that when the Voting Rights Act was reauthorized in 2006, it's not that long ago, but they don't remember it. It passed the U.S. Senate 98-0. And it was the Voting Rights Act of 2000. I mean, the Voting Rights Act amendment, that statute was, I can tell you why it was great, but I can also tell you that it was a deeply intrusive federal statute that displaced state and local autonomy. And if you care deeply about federalism, it was intrusive. And it imposed requirements on local governments. I think they were good requirements, but requirements that required local officials and federal officials to make race-conscious decisions, because complying with the statute required jurisdictions not simply to refrain from intentionally discriminating, but to ensure that the electoral rules they implemented didn't have a discriminatory effect. Mm-hmm. And thinking about that requires one to think about race and the racial impacts of rules. And I would be thrilled. We can talk about that for the rest of our time and like what that did and why that statute was important and why to my mind, good things came from the way those provisions operated. But for now, it seems amazing to me that in 2006, the United States Senate was unanimous on that point.
Right. Yeah.
Which is impossible to imagine. And in the year today, and in the years that followed, we began to see a sort of erosion of a certain discourse in the sense people started speaking out against the Voting Rights Act.
Mm-hmm.
Justice Scalia was very firm and like he thought the 98-0 was proof the statute was not the product of deliberation and a flawed process, and the court needed to step in. And that's a separate argument we can discuss. But there was not that long ago a kind of consensus, dare I say,
yeah,
doesn't stand up and say, I want to make it harder for people to vote.
Yeah.
I think the Voting Rights Act is a bad thing. And there's a lot about the Voting Rights Act that's controversial, and we can have again, like that could be debated, but so much of our political discourse didn't involve that.
Mm-hmm.
And today, the degree to which elected officials, public officials will stand up and say things about making it harder for people to vote is a shift and a change. And that is only the tip of the iceberg, sorry to talk in cliches, of this question about, what some people believe and other people believe.
Yeah.
I think one thing that was disheartening on the night of the election even was the notion that half of this country, half, you can say the numbers, a little more than half, thought we could not continue on the path that we're on. And not quite half the country, but a good portion of the country thought continuing on this path was the better course. And that's true in every election, of course. And yet at this moment, it does seem that we're divided in a way that I can't understand how anybody can think of this issue differently than I do. I can't understand how someone thinks, whichever way you come out on this question. And I don't know how we get past that and how we have a discussion or how we move forward from that.
That whole question touches on or directly addresses our topic last month with your colleague Glenn Niehoff on the First Amendment.
Mm-hmm.
And the problem in a democracy of a large segment of the media infrastructure spewing lies and hatred all the time, and quite intentionally creating a separate reality. So that's a big, it's beyond the scope of your expertise, right? But it's a problem that all of us are very worried about in terms of the health of our democracy. Mm-hmm. Other questions? Let's see. Well, here's an interesting question. So do you think federal voting legislation standardizing and improving access is a good thing for voting rights, or is decentralization a security benefit? Or does the security benefit of decentralization outweigh it?
I'm not sure that decentralization is a security benefit. We have an immensely decentralized election process. We also have, lots of local school districts, and I say this not to change the subject. That's the way we run our schools. This is the way we run our elections. I don't see that changing. And in some ways, we could be France and have a really centralized school system. We're not going to go there. I don't see that we're going to shift dramatically from the local control over elections. I think there are dramatic things that federal voting rights legislation can do to improve things, and I would like to see that. I think there is something hopeful about local involvement. And I'll talk about my fabulous students who put in hundreds and hundreds of hours over, the last weeks and months, manning hotlines, registering voters, and serving as poll watchers on election day and at the counting thereafter. And I think there is something about that involvement of neighbors and citizens at the local level that might sound Pollyannish at this moment, but also is quite valuable to, creating meaning and understanding what democracy is, to say it in that sort of way. So I think that, you know, I wouldn't, we would lose something. It's not going to happen. We're not going to totally centralize everything. So, and I don't know, you know, we can talk about it, but I don't see that. I think this is the system that we're going to have, and that the important thing is to think of ways to help these armies of local volunteers who really work, and all the people who are acting in good faith and want to see the system work properly, to make sure they have the tools and the resources. One of the things the federal government could do is put a whole lot of money into better machines, equipment, polling places, and maybe that's back to the other question, possibly something that can be done without Congress, through executive action of various sorts. Obviously more could be done with Congress, but there would be some room for that.
To do what? To standardize voting machines, to standardize number of voting places per precinct, that executive action could.
Yeah, to help process ballots, to have better equipment, update the equipment, have the equipment be more secure than it presently is. I mean, there are things that'd
be helpful. That'd be great.
And could help with vision of a whole, you know, centralizing it at some level. And I don't think that's what the question is getting at, but
no, but I'm glad to hear that, and that'd be really helpful. And, you know, just quickly to your point about all the tens of thousands of people, I'm sure many people on this call were involved in, you know, in very intimate ways in the voting process, and Democrats and Republicans as well, except for, with the one glaring exception in Wayne County last night. Apparently, countrywide, nationwide, Democrats and Republicans have done their work as citizens, you know, taken it very seriously and done a superb job to administer the election. So shout out to that. Let's see what else we've got here. Actually, you know, something came in earlier, and I want to ask you about this, about the role of a multi-party system in maybe diffusing some of the discourse, you know, of the hatred and the division. I mean, what do you think about that? I mean, obviously, ranked choice voting is starting to kind of bubble up to the surface in some localities, at least. I don't think states have instituted ranked choice voting, but what do you think about that? Is that kind of is that a partial solution for our democracy right now, potentially?
So in some sense, sure. And ranked choice voting is actually one of the things that, you know, is sort of a promising reform, both to encourage minority party views to find support without, you know, there's good reason to support it. Maine has it right now. Several local jurisdictions do have it. So many of our electoral rules foster the two-party system. Just single member districts, first past the post, majority rule requirements. We're not, so like at the big picture, we're going to always have this two-party system because of our districted elections. Spend a lot of time in my class talking about district lines and constitutional and statutory restrictions on them, or non-restrictions on them in the partisan gerrymandering context, but also in racial vote dilution and the like. And there's a moment every semester students are like, oh my goodness, couldn't we just have a proportional system? And there's a lot to be said for that, you know, and not drawing the lines and having, you know, a system where that would also encourage the creation of other parties. I don't see that happening. You know, like our districted elections are something that, you know, had for a really long time. We do see benefits in having a representative who speaks to just the district, or at least is representing the district, and I don't see that changing. At the same time, ranked choice voting, there are rules, rules about primary participation, the way we structure the rules for access to the primaries, nonpartisan primaries, jungle primaries, different ways of understanding it. There are things we can do, sort of obscure rules about fusion that would encourage third parties, or at least make it easier, debate access, different things. So ultimately, I don't think we're going to be able to without the kind of revolution that would require multiple constitutional amendments. Ultimately, I mean, not Congress could
Right.
could. It doesn't have to be that way. Congress could just be proportional. We could do it that way if Congress passed a statute to allow for it. Again, I don't see that happening, but there are ways we could push and encourage a greater diversity of parties than our system presently allows. And you know, I think that's a good thing.
Probably would help with the discourse. Let's see. Here's a question. The work of the League has always been pursued in a nonpartisan manner. I haven't read this first, so we'll all be surprised. In the last few years, voter education and expanding voter rights have come to be seen as partisan. Oh, yeah. Any advice on how to rescue the idea of nonpartisanship in an era where one party is actively working against voting rights? Really interesting question.
Yeah, I mean, I don't know the answer to that. You know, some of it is also the discourse. So one can say, am I actively working against voting rights? I'm concerned about issues of fraud. I'm concerned about issues of exploitation in people being manipulated with absentee ballots or the reliability of it. So part of me wants to say, like, let's talk about that concern and let me show you why that concern is both overblown and not sufficiently tailored. That the rules that we're putting in place to advance those concerns are too crude and too burdensome, to my mind, to support that. I don't know. I don't have a lot of hope there. I don't, you know, I'm all in favor of vote suppression.
Yeah, right. Well, I mean, some have actually come out and said, if all of these people vote, we'll never, our party will never be elected again. So yeah. I mean, it has been stated, actually, frankly.
Right. I mean, within that, even a statement like that, which, you know, there is the sense like that only people who are eligible ought to vote. I don't think voter fraud is a problem in this country.
Well, that's been demonstrated over and over.
In-person voter fraud does not occur.
Right.
We've submitted absentee ballot fraud. There was a case in North Carolina in 2018 where they had to rerun the election. So it does happen, not to the degree that folks that the discourse allows. So I don't know the answer for that. I would like to see, common ground on the notion that everybody should vote, that we shouldn't be making, putting needless obstacles in people's way. And that's sort of back to where we started here. Back in Wisconsin in that earlier case I mentioned, I think the point is tied doctrinally to this idea that what your constitutionally protected right to vote is a legal right to cast a ballot, no matter how, and this is my take on it, but like that all sorts of restrictions that make it very difficult, long lines, registration obstacles, identification requirements that some people don't have access to. University of Michigan gives me an ID, which I managed to lose with some frequency, but when I can get another one. I have a driver's license because that's something I independently need, that I decided I want and have. But for people who don't have those types of identification, voter ID can be quite onerous and compounded by state laws that make eligible IDs that predictable populations will not have. Yeah. So we know who's not going to have a qualifying ID. And honestly, I mean, I would like to not see that as rule. I think those laws should not be passed. I think people should oppose them. And I think we're seeing difficulty now. Federal courts aren't going to displace them. And so we need to change how people think about certain issues. And I would like to return to the good old days of, 2006. Actually,
right.
That good.
Right.
But where there was some, at least greater consensus than we're seeing at the moment about
right.
It's not an answer.
Well, so this is a very, very legally naive question. So I'm an English major, so that's my excuse. I just keep going back to the possibility of executive action and
Yeah.
what executive action can accomplish. How far executive action can reach into state right territory. So gerrymandering, for instance, because, most people agree that it should be easy to vote. Most people agree that 90% of people agree that we should have universal background checks for gun purchases, for instance. But those views aren't represented in our legislative bodies, in part because of gerrymandering. So, for instance, I mean, we passed Voters Not Politicians. That was 2, right? Prop 2 in 2018. So good for us. But a lot of states haven't pulled that together yet. Is there anything the executive could do that would affect how boundaries are drawn in states, or put constraints on how boundaries are drawn in states?
So here's, I think there are things Congress could do.
I know that. No, I know that.
Congress could create some rules about, compact, contiguous, respecting political subdivisions. There are criteria that would do something.
Right.
I say, like, we have this redistricting commission here. There is a legal challenge coming to that redistricting commission. I'm not talking out of school here. I mean, this is clearly coming. Arizona had a redistricting commission 2016, 17, I should remember what year it was, challenged in the Supreme Court. Supreme Court upholds it. And the legal challenge there is a legal challenge that's based on a variation of this claim I mentioned earlier about the independent state legislature. So, and it actually has to do with the state legislatures getting to decide the time and manner for federal elections unless Congress speaks to it. Well, so then there's a hard question. I didn't think it was a hard question at the time, but it turns out to be a hard question. What is an independent redistricting commission? Is it the legislature?
Yeah.
And the decision, Arizona Independent Redistricting Commission, the Supreme Court in a 5-4 decision said—
the U.S. Supreme Court.
The Supreme Court said it's fine. A legislature, we should think, is not just the actions of that building with the columns and the dome, but it's lawmaking power more broadly. That was a decision that has 4 justices dissenting. That was a decision written by Ruth Bader Ginsburg with Justice Kennedy as the decisive 5th vote. So it hasn't cycled back. We don't have that Supreme Court, but I wouldn't have a lot of confidence in that precedent going forward, or at least there's a reason to think that precedent will be revisited. Maybe the court will affirm it. We don't know. There were people who were not on the court who are there now, might have different views of this, although some of the things that some of them said about the Pennsylvania case, it's not the same issue, but doesn't bode well for the continued validity of independent commissions with regard to at least the lines for federal elections. That's a case that's coming. So so I'm raining on your parade. It's not like, oh, what about those other states that haven't fixed what we fixed? There's us.
Yeah, okay. Well, yeah, that sucks. That's why you're a little bit worried long term.
Yeah.
Let's see. Here's a question. Speaker might discuss Board of Canvassers meeting on Monday, November 23rd, tentatively at 1 p.m. I think this is in Michigan, where there could be a repeated voter suppression racism seen in Detroit yesterday. Strong need for citizens to contact state legislators to demand certification, and need for citizens to attend meeting in person. Do you have any comments about that?
I don't. My understanding is that, I don't. I believe all counties have certified their vote in Michigan at this point, and that what the State Board of Canvassers has to do right now is a ministerial act.
Right.
That doesn't mean, Wayne County had to do a ministerial act. So I don't know. I sort of think, so I don't know. And if you want to talk about, local involvement, citizen involvement, it was an interesting interesting display yesterday.
It was.
The way in which public comments, like, we don't know why the board shifted after voting one way and then voted the other way, but you saw ordinary citizens getting up and saying, this is wrong, this is wrong, this is wrong, this is wrong, and then then there was a shift. That's an interesting
Yeah.
narrative, an example of local involvement. So
I thought that was really, really impressive organization on the local activist part. Okay. Okay, so as an election, this is from Rena Bash, who is the clerk for Ann Arbor Township. As an election administrator, I've come to believe that the decentralization of our voting systems is indeed a security feature. Maine has instituted ranked choice voting statewide. New York City uses ranked choice voting now. Okay, so she's not really asking a question, but just saying. Do you want to comment on that at all?
I think ranked choice voting is, a promising idea, and one that we could implement statewide. We can implement it locally. There's that thing again about Congress implementing. It's not going to do it, but yeah, I'd like to. Based on what I know about it, I think it would help. On a lot of fronts. Yeah.
Okay. Well, slightly to that point, as you stated, slightly less than half of American voters see we should not change course. If we don't understand what issues, not the vitriol, that the voting segment support, we'll never get to any consensus on how to move forward. How do we understand the overarching issues on both sides?
Yeah, I wish I had an answer to that.
Yeah, okay.
You mentioned several things, that we think that there's a lot of agreement on. And actually the partisan gerrymandering is an interesting one in that, because so many people are like, oh, that doesn't sound right.
Right, right.
It has a sort of like, it seems like there's a lot of consensus, and we are definitely having difficulty translating that consensus into policy.
Right.
There's a lot of different reasons for that. Gerrymandering itself is a reason for that.
Is a reason for that, a huge reason.
Campaign finance is a reason for that. Who has a voice and who's shaping, what our elected officials are saying and doing.
Right.
Yeah, I do not have an answer for how we build the bridges that need to be built. I don't think we can go, I don't think it's a long-term solution for, us to simply like, there's them and there's us, or, however we want to define who we are and who they are, and people might vary, will vary on which side they're on. The notion that there's no common ground is deeply difficult.
Yeah.
And you see these political scientists do this. It's sort of, it used to be that the Congress sort of went from the most conservative to the most liberal member. The votes would appear as just a one-hump camel, if you will. And now we actually see two humps, meaning that the most conservative Democrat is to the left of the most liberal Republican. And so there's no, and you can't govern that way because there isn't common ground, and it's,
right.
It's difficult at the federal level.
It's paralysis. It's a recipe for paralysis. That's really, really scary. Let me see what other questions we have here. Well, one question is in the chat is, where did you see successful voter suppression in this election?
I'm sorry, just say a little bit more successful.
Where did you see successful voter suppression in this election? Was there successful voter suppression in this election?
Look, turnout was very high. And so in some ways, how do you, what the word is, maybe this is part of the discussion of finding some common ground. So what do we mean when we talk about voter suppression? And is it any regulation of the electoral process? That can't be. Rules that make voting more difficult? without adequate cause. Maybe I'd put something like that. The insistence that people show up in Wisconsin, in Milwaukee on April 7th, 8th, in the early days of this, because the absentee ballot they requested never arrived. And that if they want to vote, this is their only option. Is that voter suppression? People voted. And actually we saw in that election, and we see now, like, lots of people voted. And so are we measuring suppression by its effect? And one of the curiosities of this election is many of the rules that made it more difficult for people to vote actually spurred, I'm going to vote. You may have seen some of these videos of people dancing or sitting with their chair, snacks, and waiting online, and doing all sorts of work to vote. And on the one hand, it's heroic. On the other hand, we shouldn't be putting people to this test. And then to just get back to your question, what are we talking about? Is that voter suppression? Because they weren't suppressed. And I'd say voter suppression, and that's where we need to actually, and maybe we can find some consensus, in the sense, it's hard to imagine you need to wait online for 12 hours. Like, it's difficult to imagine someone say, and it's not impossible to imagine, but that shouldn't be the rule. And what can we do to make lines shorter? One of the things that I actually was very encouraged back in 2018 in Michigan, with Prop 3, a lot of the rules about early voting and absentee and on-demand found support throughout the state. It didn't only pass by a large margin, but county officials, county clerks in lots of different counties said, these rules will help us run better elections.
Right.
Rules will be helpful. And so, I do think people, like, that should, the lines will be shorter and we'll be able to handle this better. So, like, maybe there's a way to think about, I don't say stop calling it voter suppression, and actually just look at rules and say, there's that debate. Let's look at this rule, and do we need to have this rule here? What can we do to make lines shorter? I think that that's something we could have consensus on.
Yeah, right.
Inclined to think about ways to do that. Not everybody.
Yeah. So maybe instead of jumping to the definition of suppression, or just calling it suppression, say this isn't helpful for making lines shorter. How can we make lines shorter? Yeah, that's really interesting. Voter intimidation, voter, throwing obstacles up, for sure, but people did vote.
Sure. And the pandemic raised, additional questions about safety at the polls, about mask wearing at the polls, in terms of intimidation and the like. And, I don't know how you solve that. People, those sorts of disputes about those behaviors, that one person's behavior is affecting someone else's, and how, I have an idea of how one should handle that, but involves a lawsuit.
Okay, let's see. Somebody has a question about the Electoral College, but I feel like that's not quite your bailiwick. Am I right? Or do you want to talk about the Electoral College?
Deep insights about the Electoral College. We could fit, the Electoral College is terrible, in terms of, if you have an intuition that, majority rule is a thing, the Electoral College ain't great, nor is the U.S. Senate.
Right.
You need the Senate, I don't know, so how do you fix that? Again, like, it's, there are proposals now for the National Voter, what's it called, Compact, where states would agree.
Yeah. Popular vote compact or something like that. Yeah.
Votes by whoever gets the electoral votes by whoever gets the popular.
Right.
Difficulty that is, some states have an incentive for that and other states don't. And right. Would hit a wall, to my knowledge, last I checked, on who's going to sign on to it. And even if it's signed on to, there's a question about its validity.
Right. Right.
New states, that's a thing. That's not that hard to do.
Right.
But that requires
congressional approval.
Yes.
Right. Okay, so the Electoral College, bad. Can we fix it? No, in all likelihood. Marcy wants to know, can you comment on what electoral issues might be brought before the U.S. Supreme Court and how they might be adjudicated given the current 6-3 conservative court majority? I think this is basically the same question restated. What is in the Supreme Court pipeline now regarding voting rights issues, and how long will it take for conservatives to tee up new voting rights issues for the Supreme Court to consider?
So one of the issues we thought we might see, which we didn't see in this round, was this Pennsylvania state court construction of state law interfering. And this, as I said, happened in Bush versus Gore. And it didn't get a majority of the court, but there were 3 justices at the time that thought the Florida Supreme Court had usurped the authority of the
legislature.
I don't think that issue is going to present itself. There were a couple of opinions, one in particular where the Chief Justice, part of this was before the newest justice took her seat, where the Chief Justice indicated his view that the state court, that it sounded like this, that he thought state courts construction of state law were not interfering with state legislative power. There were, I'm counting right, 4 other justices who felt otherwise. I believe it was 4. So, you know, the new justice could have made a difference on that. That issue didn't present itself. There's the Independent Redistricting Commission question. There's no case in the pipeline yet. I expect to see that case. There are other cases I've expected to see that haven't happened, so who knows, but that one strikes me as it's on its way. There's the Arizona Voting Rights Act case that I mentioned that involves the out-of-precinct provisional ballots being thrown out. And there's a second issue in that case that Arizona adopted rules that limit the ability of someone to collect absentee ballots. This word is harvesting, help people collect them. And it actually particularly is an important issue, particularly in Native American communities where many people don't have conventional, mailing, standard post office addresses and things. And so this service, it has an impact. The Ninth Circuit sitting en banc, meaning the full court, heard the case and in a divided opinion said, these practices violate the Voting Rights Act. The remaining provision of the Voting Rights Act, not the one that was struck down in Shelby County, but Section 2, this prohibition on standard practices and procedures that result in a minority community having less opportunity to participate and elect representatives of choice. It's a complicated standard. The Ninth Circuit said these 2 rules violate that because of their impacts on minority communities in Arizona. Supreme Court granted cert, meaning agreed to hear that case. I don't think they agreed to hear that case to say, good job, Ninth Circuit. Like that's that case. We don't know. The court hasn't heard a Section 2 case on its merits in quite some time. There are several justices on the court who have never said anything about it. I don't, based on things that we know about the newer justices and the justices that are there, I don't see a I don't see a majority for an expansive reading of Section 2 of the Voting Rights Act. That said, who knows? I spent last spring, or winter term as we call it, was teaching employment discrimination, and we were discussing extensively this Title VII prevent discrimination by employers on the basis of sexual orientation or transgender status. And I told my students, 37 times, this case isn't coming out the way you want this case to come out. And I was wrong about that. And they all, emailed me and told me I was wrong about it. So, you don't know.
Yeah, that was a surprise. Yeah.
What's in the pipeline? Those are some of the issues that are there. Obviously, the census is completed such as it was. Every jurisdiction is going to redistrict. We're going to have lots and lots of districting plans. We will know, this will be the first round of redistricting after the demise of those pivotal provisions of the Voting Rights Act. We still have this other provision. We know that partisan gerrymandering is not going to be a constraint on this process. So there will be legal challenges based on the Section 2 provision. So coming again, racial gerrymandering cases. So we'll see. There will be, there's always something coming up.
Let me ask you, this is a pretty technical question for me. And that is that the challenges, the Supreme Court challenges to the citizens redistricting commissions. Are we vulnerable to that as well? Since, I mean, our process was to change the state constitution to allow it.
Yeah.
So, I mean, we changed the state constitution according to the rules set forth in the Constitution. So that seems to me like that would not be subject to that kind of a challenge. She smiled.
Yeah, no, I think that's right. I mean, the same thing, I believe that was true in Arizona as well.
It was the same thing. Oh.
And the argument is that whatever we say, we can make our constitution say what we want. The federal constitution vests in the legislature the authority to set the time, place, and manner of federal elections, subject to whatever exceptions Congress shall make. So leave that exceptions clause out, because that's not what we're talking about. And the legal question is whether we, the voters in Michigan, in creating this commission, have usurped, we the voters or the commission itself, usurped the power of the legislature to set the time, place, and manner of federal elections, not for state and local, and the commission will still be fine for state, for the House,
Yeah.
the state Senate, which is not nothing.
Yeah.
And this case will come out. And I think they're, hard questions. What does it mean, the legislature? The legislature operating independent of judicial review, the legislature operating independent of state constitutional requirements. Justice Ginsburg's opinion in the Arizona redistricting case, independent redistricting commission case, spoke of the legislature as the source of lawmaking authority, that the initiative, that the referendum was not known to the folks who framed the original Constitution.
Yeah.
The word legislature, they were using that as a proxy for this kind of behavior, and this is something we should be allowed to do. That could carry the day.
Yeah.
Good. We'll see. And let me add something a little bit more optimistic about that. When the Supreme Court in the North Carolina partisan gerrymandering case 2 years ago now, the Rucho case, the Supreme Court, the U.S. Constitution isn't going to stop partisan gerrymandering. We are not going to read the Equal Protection Clause. We are not going to read the First Amendment to prevent the drawing of lines for partisan gain. We can't. It's not within our power. One of the things Chief Justice Roberts said in that opinion is, look, I'm not saying partisan gerrymandering is great. I'm just saying that the U.S. Constitution is not the device, the vehicle to stop it. And there are other things that could be done. For instance, Congress could pass a statute. That's one of the states could pass statutes, state legislatures at least. And he also mentions these commissions as something. And he says, I'm not expressing any opinion about that. And it's a curious line because presented in that Arizona case I mentioned, so he doesn't seem to think it's great, and yet here he's saying this, so maybe he thinks differently about it now. I don't know. So a lot of people spend a lot of time, what's the Supreme Court going to do in this? There are reasons, to not be too sure. There's worried.
Yeah. We're almost out of time. This is, once again, thank you so much for helping us understand such a, difficult, complicated topic of so much importance to our lives. We appreciate your time. We always try to, and expertise, we always try to end with some sense of what individuals can do to protect American democracy, because that's what the League is all about, as you know. So what can we do? 3 things, maybe 4, 10, whatever number you have to help us ensure the health of America's democracy. Concrete steps.
So, I think a lot of things that a lot of people were doing before the last election. So making sure they're registered to vote, making sure everybody is registered to vote, and you heard about this and had a plan to vote and followed through. And people run into trouble lots of times, like you could Google that answer. Sometimes people need help Googling that answer and finding how to do it. So I think lots of people did lots of good work in that. poll watching. I think those were all important things that people did in this election. There are improvements I would like to see. I would like to see efforts to, pilots. I think there are things we can still do at the state level. I think we have, a Secretary of State who does a sensational job, in my estimation.
Amazing. Yeah.
Seeking to make sure people are participating statewide and looking at people are running into trouble. I could have a wish list of amendments. There are things that are done in other states that we don't do, pre-registering 16 and 17-year-olds, particularly when driver's licenses and those encounters with state authorities at that point. Different views about, whether that could we do more to engage people. I see it on, this is not, I see it on campuses. We have, better voter registration among students and higher participation than we've seen in recent years. I still think the numbers are, incredibly too small. So I would like to see, more people voting. I like the ranked choice. I know there's talk about putting that on the ballot in 2020, maybe 2021 even. I would support, a well-crafted proposal there. So it's all a little, after an election, be nice to your neighbors, as about what we can do. I don't know. Think about proposals. I don't know. I would like to see Congress take some action, because I think there are things Congress could do that could make voting better nationwide. And I would like to see a de-escalation in the rhetoric, and that this is not, I don't have a lesson for how to do it, but I would like to see a way that we could come to common ground on, protecting the vote in a meaningful way through really common sense, simple legislation that would survive scrutiny in federal court. How to make that happen. That would inspire me.
Okay, so this election saw such an outpouring of volunteer activity, just incredible dedicated activity, because I think for the first time in many of our lifetimes, we felt our democracy was actually at risk. And so your prescription is to keep it up. Yeah, right? Keep it up. It's not one election, it's a whole long set.
I can, yes, and I can say that, I'll say sort of my reaction to my students who, I think felt deflated after all of this.
Yeah.
And compounded by everyone's experience now taking all their classes online and sort of the difficulties of this moment more generally. I think they realize it isn't something we're going to be done with.
Right.
It's not like, oh, now that problem is solved and we don't have to pay attention to it.
Right.
This will always be something. And
Right.
some of it, it would be nice if it was more of a consensus issue. The pandemic presented a host of problems that, were unanticipated and needed to be confronted. And I think every election will present challenges, some of our own making and some aren't. So, I think the notion that this is a continuing process and that this will always be something that will be contested and that there will be struggle over and we'll have to figure out the rules for isn't something to despair over, but rather, it's baked into our system, and I don't know, we should embrace it and just keep working at it, and know that there'll be successes and failures and hope the successes outweigh the failures. But that's quite an insipid notion to end on. But
that's okay. I would add, and also to be sure to take care of oneself, so you can so you can stay in it for the long haul, because it can be pretty punishing, as in for your students, thinking we're going to have one major all-out push and then solve this, and that is not how it works. Yeah, we almost lost our. Sorry.
I'll add one more thought. When we talk about the vote, a lot of my voting class has become a legal history class at this point, because so many of the laws are receded in the Voting Rights Act and campaign finance regulation and the like. And I asked them to watch the episode of the Eyes on the Prize series that involves the protests in Selma that lead up to the Voting Rights Act. And now they've been doing it for years, but there's been lots of movies on it. And it's obviously in everybody's popular imagination. But I think it's worth, in a year that John Lewis died, to sort of, worth to know, you know, I tell my students this because he was, you know, younger than many of them when he walked across that bridge.
Right.
And, you know, if he could have had the, you know, expectation that this can change, you know, how dare the rest of us sort of feel like this is hopeless, you know?
Right.
I mean, there's so much good that's happened, and there's, you know, things that need to be fixed and a lot of work to be done, but
Right.
that's not a new story in this country. And you know, many
Right.
of us are in a place where we really are, you know, very privileged in the opportunities that we have. And, you know, so that we have to police this and fight for, you know, expanding voter participation, one might say is the least we can do.
Yeah. Now, see, that wasn't banal at all. Thank you. That was wonderful. Thank you so much, Ellen. We really appreciate it. Thanks, everybody, for joining us today. This was the League of Women Voters, Brews and Views. And again, I'll just mention that we're a nonpartisan voter education organization. Thank you very much. We will not, I will add, we will not have a Brews and Views in December. We're taking a month off for self-care. So everybody have a good month. And we'll see you in January.